Please help me welcome Alex Glazier.
Good morning. Everyone ready for a little law and ethics with your coffee? You know it's exciting. I am a law professor, but I promise I won't call on you. On the other hand, we will have, hopefully, some good opportunity at the end to discuss and ask questions. So I was asked to talk a little bit today about why gift law matters, the law and the ethics behind donor designation. And to start, what I would like to do is to provide some legal background. So the basis for deceased donation in the U.S., the legal basis, is the Uniform Anatomical Gift Act, and we call this the UAGA. Now, it's uniform because it's been passed in every state, and it's a model piece of legislation. There's a group called the Uniform Commissioners. The governors of each state appoint individuals to be on that commission, and they look at areas of the law where, from a policy perspective, it would really be ideal for there to be consistency across the states. This is not a new law. It was first drafted in 1968, and it's been revised a couple of times, 87 and most recently in 2006. And their revisions really reflect changes that have happened in the practice, which have been really significant. And although donation transplant is a young field, it evolves very rapidly. So, as mentioned, this is a state law. And the reason why it has to be a state law, for any of you interested in a little constitutional law this morning, is because consent is a reserved power for the state. So what that means is that while transplantation is regulated federally, the laws governing authorization for donation really need to be done on a state-by-state basis. So every state has passed the UAGA, and as I said, it's uniform, although that said, there's of course variations. I can imagine telling Alaska that they have to do things exactly the same as everyone else, probably not gonna fly, right? And we have our own examples in New England as well. So the legal framework in each state is the same. The UAGA has been passed, as I said, in every state, and now in the most recent version, 2006, has been passed in 47 states, including all of the ones in your region here. But that said, there are some slight state-by-state variations. So just to engage you a little bit, I want to start with a question. The law requires informed consent for deceased organ donation. So can I see a show of hands for true? Can I see a show of hands for false? Okay, this is pretty good. Lots of people not raising their hand, and you're thinking, that's why I'm here today, to answer this question, so I can hear a lawyer give the answer rather than try and guess. So the answer, in fact, is false. And I think that this is actually surprising for most people, although it seems like we have a pretty well-informed group here. Maybe you were looking at the preview slides because it was up there. But I think the reason why this is often surprising, especially when I'm speaking to medical staff, is because informed consent is really the term of art that you work with, that you understand you work with on a daily basis, right? You operate within informed consent when you're a healthcare provider, and shifting that paradigm for deceased donation can really be difficult. So the UAGA is not based on informed consent. And this is why we like to use the word authorization. It really is a preferred term only because we're trying to distinguish it from informed consent, but both have the same legal meaning in the sense that we're talking about legal permission. So informed consent is the legal principle that applies to healthcare treatment decisions because it's really all about ensuring a facilitated understanding of the risks and the benefits to a patient of a particular treatment, alternative, or procedure. And it's born from a legal matter. It is born out of the doctor-patient fiduciary relationship. So with deceased donation, there really are neither risks nor are there benefits to the deceased donor. Right? There's no risks and there's no benefits to the deceased donor because the donor is deceased when the organs are recovered. And although that seems obvious, I think it's really important to say because it provides some understanding and insight as to why informed consent was not selected as the legal framework under the UADA. if you're wondering, are there any other examples that are sort of outside of informed consent that you might be familiar with? And yes, there are. So advance directives could be signed by a patient at their home by themselves with as much or as little information as they may choose to avail themselves of. And certainly other postmortem decisions like burial direction and whether or not cremation might be what's wanted are also decisions that are made really outside of informed consent. So the question is then, though, if donation laws are not based on informed consent, really what are they based on? And the law recognizes two ways to transfer something from one person to another, right? So the first way, which we're most familiar with, is contract. But contract requires the exchange of something. Anybody want to give me the answer of what does a contract require? Exchange of something. Ooh, everyone's quiet today. Okay, so contract requires the exchange of money, right? And so this really doesn't work in the donation context for a number of reasons, including the fact that it's a federal crime to buy and sell organs, right? So the concept of contract as providing the legal framework for organ donation was really not going to be an appropriate one to use. And so the alternative is gift. This is how the law defines gift. Very simple. This is any kind of gift. It's a voluntary and legally binding, uncompensated transfer. So it turns out it's really important that it's legally binding. The donor cannot ask for it back. And it is really key that the legal framework selected was one that really accommodated the realities of donation and ensured that it was a legally binding transfer that's done voluntarily and doesn't include the exchange of money. So the choice of gift law as the primary legal principle in the UAGA was really very purposeful. And as I said, it fits the reality of organ donation and it provides the legal certainty that we need. As a general matter, and I'm not going to expect that you remember this, but I think it's important to provide it to you, that gift law in the US requires three elements, any kind of gift. And it's pretty simple. There needs to be an intent to give. There needs to be the actual transfer of what's being given, and there has to be acceptance. And each of these three elements is incorporated in the UAGA. What the UAGA does is it takes that common law of gifts, those three elements I just described, and it puts some very specific parameters on it. So with deceased donation, the gift is conditional, of course, on death. So the right to recover gifted organs occurs at the time of death. And also, it's conditional on clinical suitability for the purpose for which it's given. And this is important because there are many individuals who would like to be donors, and unfortunately, as we already saw, only about 1% may be eligible for organ donation in any event. And so that medical suitability for the purpose for which the gift is given is really important and incorporated into the law. The gift is also limited under the UAGA. It's limited by purpose, and transplantation therapy is given the highest priority as it should. And then the other purposes for which the gifted organs or tissues can be used are research and education. Okay, so with that background, I think that in context of gift law as the primary legal principle behind organ donation, I think we really can frame this concept of first-person authorization. And when I use that term, this is what I mean. Adult individuals have the right to make a legally binding anatomical gift prior to death. So I think that's as simply put as I can. So what the UAGA has to say about this is that, in fact, the adult individual is the primary donation decision maker. And if you're wondering if that's new, it's not new. This was in the 1968 original version of the UAGA, that individuals would be the primary donation decision makers for themselves. And really only in the absence of an indication by an individual themselves would we look towards a surrogate decision maker for donation. And as most of you probably know, the statute lays out a very specific list in priority of whom we would approach for surrogate decision-making in the absence of first-person authorization. So that's things like healthcare proxy, spouse, adult child, et cetera. The UAGA also talks about a document of gift, and that's sort of the legal, technical term, and really what that's getting at is that there needs to be some documentation of those elements of gift, that there's an intent to make a gift and authorization to transfer that gift to a potential recipient. And this really satisfies, as I said, that first element of gift law. We need to know that there's what the law calls donative intent, and there it is. And the document of gift also needs to be signed, and that could be done in many ways in today's world. That can be electronic, to satisfy the UAGA. So a question for you. Which of the following are legally recognized ways to make a gift? Signing up for the donor registry, statement in a will, verbal statement, all of the above. You can tell I'm a teacher. A and B, but not C. Okay, so how many hands for A? Okay. B? C? D, all of the above? And E. Okay, pretty good. So the answer is E. We know that signing up for the donor registry at the DMV is one of the ways you can make an anatomical gift. That constitutes a document of gift, and we're going to talk a little bit more about that in a minute. Written statement in a will, well, that's been in there since 1968. Always a little strange when someone shows up with a will at the hospital. Always have to wonder what's going on there. But occasionally that will happen, and that's fine. And it could also be that it's a written statement in another document, like an advance directive. Verbal statements, not so much, right? So what the law is trying to do is set some formality to this document of gift idea. The donor registries really have changed first-person authorization. So as I mentioned before, the idea that an adult is the primary donation decision maker for themselves started in 1968. But back then, really, there wasn't any mechanism for the right information to get to the right people at the right time. It was largely dependent on either donor cards or, again, wills, none of which tended to be found at the right time. So over the past decade, the change in donor registrations, which I really like to think of as an electronic donor card, so again, a mechanism to make sure that the right people have the right information at the right time, have significantly changed the ability for all of us to coordinate first-person authorization. So just a question for you. How many registered donors in the U.S.? Where are we at today? Hands for 5 million? 25 million? 50 million? Over 100 million? I should have told the OPO folks they're not allowed to vote. We're over 100 million, and I think most healthcare providers find that surprising. Take a look at this. Here we are. That's amazing. This is the US numbers here, as recent as through the first quarter there in 2013, and we're over 110 million registered donors in the US, and this is fantastic and largely due to the efforts of people like yourselves to make this a priority. What this means for us in practice is that a significant number, percent, of actual potential organ and tissue donors, and this is broken out, organ donors, tissue donors, eye donors, authorize donation themselves through a donor registry. So you can see in 2007, and we weren't collecting, this by the way is from Donate Life America, this is their data. In 2007, there was data on organ donors and tissue donors, not eyes quite yet, but you can see it was at 19%, 27% tissue donors. This is actual recovered donors that had authorized the donation themselves through the registry. To 2012, where we're really at a much significantly different point, 40%, 45%, 48%. And I understand here in your region that the number of registered donors as a percent of the adult population greatly exceeds the national average, which is about 50% of adults. And in this region, it's closer to 70, which is incredibly impressive. And probably also reflected in the percent of actual donors who authorize the donation themselves through the registry. So what this means is first-person authorization in registered donors is really an everyday part of coordinating donation now. It's not the rare case, it's the average case. So what does this mean? We've got registered donors, and does it mean that we don't need to work with a family? Of course not. Collaboration with the family is absolutely key, and in fact, disclosure of the registration status and discussion of what the process will involve is required by some state laws. It's certainly part of the CMS regulations that we work with, and it's standard practice for OPOs. So I like to think of first-person authorization as the legal permission, and that's a floor, not a ceiling, for how we coordinate organ donation, tissue too. Families remain a critical piece of that. If you're wondering about the ethics of all this, it's actually pretty straightforward. It's an autonomy concept, that adults have the right to make their own decisions, this idea of self-determination, which is also supported in how we ethically support advanced directives, right? So then I get this question. This says, okay, Mom, I'm sorry I regifted one of the kidneys you gave me. And what I mean by this cartoon is that family members don't always have the same feeling that the patient might have about donation, and sometimes object to the fact that the patient was a registered donor. And the question I often get is, what do we do when that occurs? So another question for you. Family can revoke donor designation at the time of a patient's death. Does the law allow for that? True? No OPO votes this time. True, some people maybe not sure. Again, this is why I'm here. You're the expert, tell me. Okay, how about false? Okay, good. So it's false. And this is one of those moments that I love as an attorney, because I almost never get to do this, but I get to say that the law is really clear. When's the last time you've heard a lawyer say that? The law is really clear, and it's got your back, another thing I often don't get to say. So I'm saying that because the UAGA is very specific about this point. First-person authorization, when there's a document of gift, that is legally binding, and family or other individuals cannot override that. They can't revoke the gift. It's really important. So what this means is it's not a legal issue. When the family's objecting, it's not a legal issue. It doesn't mean that there aren't other considerations, and I'm going to talk a little bit about how to handle those. But it's not a legal issue. This isn't about we're worried about being sued. The law is quite clear. And the reason why I'm saying it's got your back is because not only is the law clear about the status of first-person authorization, but the UAGA includes a provision that grants immunity from liability for those who follow it in good faith. And this is quite extraordinary. There are very few laws that have this in them. And this has been in the UAGA since the 1968 version. And it's really an indication of the legislators understanding that we work within critically short time periods. And we need to be able to rely quickly on the information we have, and there should be a policy of encouraging donation to move forward. If you're wondering if that's ever been tested, it has, at least twice to my knowledge, and it's been upheld. Okay. The gift can be accepted or declined. Remember, in those elements, you've got the intent, the transfer, and the acceptance. So what that means is the OPO, working with the hospital, still needs to decide how they're going to move forward. And if ultimately they decide not to move forward, the gift can be declined. So say every once in a while I'm asked, well, could there be liability if we don't move forward? And the answer is probably not, but it's the wrong question, because the question should be, how do we move forward? And let's talk about that a little bit. What are the ethics of this? Well, again, remember back a couple slides, the ethics are pretty simple. This is about respecting the autonomy rights of the donor, right? And maximizing the potential good. We're all here because we want to save lives. And that's what this is about. You need to bring that back around. I think the other important thing to say, too, is that remember that donor registries are not designed to be an informed consent process, because this is where I often get that question. Right? You go to the registry to sign up. It's not an informed consent process, and it's not intended to be, and it doesn't need to be. This is about gift law. You have, as an adult, the ability to make a gift or to not make a gift. So what do you do? Well, number one, hospital staff knowledge of the law is important, and that's part, I think, of what I'm doing here today. It's important because, again, this doesn't end up being a legal issue. It's not a legal issue, but it's important that everyone's clear on that point. I have some suggestions on how to move forward. I think an escalation protocol makes a lot of sense, right? So one of the things I tell our own OPO on the rare cases where this has come up is let's understand the basis of the family objection. For example, we want to make sure that it's not about an error. This isn't the right guy, the address isn't correct, the name's wrong, the date of birth doesn't match up. So let's make sure we're clear we've got the right individual in the registry. What's the basis of the objection? And also, what's the transplant potential? Because, again, we're doing this to save lives, right? So no one's interested in upsetting families and causing conflict if we're not going to be able to transplant. But assuming that there is transplant potential, and we understand the basis of the family objection, and it's not based on an error or some more recent document where the individual decided they did not want to be a donor, then you really need to have a plan in place so that this can be a coordinated decision between the OPO and the hospital on how to make it move forward. In New England, where we've been following first-person authorization for about 10 years, there's only been a handful of cases that have even gotten to this point. So while it's really important to discuss this because everyone's concerned, what do we do when this happens, I think it's important also to say that this is absolutely the exception and not the norm. So with that, I'm going to leave you with this quote. This is a great quote. So William Shedd was a Vermont Calvinist, and being from New England, I absolutely had to bring a little bit of New England here to the Pacific Northwest. And I love this because it really applies to what we're talking about. There's two takeaways here. One, don't be afraid to use the donor registries as clear permission for donation. Right? They were established to empower the public to make their own donation decisions, and they're meaningless if we don't use them that way. And the second is we should acknowledge that there's some risks. And there may not be legal risks, but there's a cost to being conservative. And the cost is that there are people dying waiting. So the least we can do is to coordinate donation when the patient, him or herself, wanted to be a donor. And here are my 4 things for you, hopefully that you can take away from this. The UAGA is the law that governs deceased donation in the U.S. It's based on gift law principles and not informed consent. That's really key. Adults can make their own legally binding donation decision prior to death, and this is supported by the ethical principle of autonomy. So with that, I am happy to take questions if we have some time.